Good morning, TCFE. We are live with our special guest, Ashley Long, intellectual property attorney. And Ashley's going to talk to us today about intellectual property. So, Ashley, we would love for you to introduce yourself.
Wonderful. Hi, everyone. My name is Ashley Long, and I'm an intellectual property attorney at the law firm of Carney, Badley, Spellman in Seattle, Washington. And I work with a lot of startups, helping them register, maintain, enforce, and commercialize their intellectual property. So today I'm going to give you just a general overview of what intellectual property is and some things you can think about when you're using it in your business. All right. Intellectual Property 101. This is a basic guide to understanding intellectual property. You've got my contact information down there. It'll also be at the end of the slide. So if you want to reach out to me afterwards with any questions, comments, feel free to do so. Okay, so in today's presentation, we're going to cover three main points. We're going to talk about understanding what intellectual property itself entails, how to manage your intellectual property, and also how to protect your intellectual property. Okay, so first off, what actually is intellectual property? Because we throw that term around a lot. I even hear other attorneys say, oh, hey, you know, I'd really like to trade my copyright. Can you help me with that? And I'm like, no. These are three distinct items. Patents, which we think of generally as an invention. A trademark, which is something that identifies you, your company, as the particular source of certain goods and or services, and copyrights. Copyrights are original works that contain some sort of creative expression, and that creativity is then rendered in a tangible medium, which I know sounds really lawyerly, but basically it means you think of something creative and you put it down in a format, whether that's source code or an artistic work, a sculpture or an architectural design. All of those things can be considered a copyright. So patents, inventions, trademarks, brands indicating that you are the source of something, and then copyrights, creative expressions. Okay, patents. How can you patent something? What thing have you made that could actually be protected under the law? Now, just to back up one moment, what we talk about today is going to, by and large, apply to U.S. law. We will talk a little bit about international considerations, but for the purposes of what can or cannot be patented, let us assume that we are speaking just to U.S. federal law. So, okay, first, the content has to be of a patentable subject matter. So that could be a process, which is an act, a series of acts or steps. It could be a machine, a concrete, tangible thing that consists of parts, has certain devices, or a combination of things. It can be manufacture, an article that's produced from something raw or prepared that gives new forms and qualities to these things. It can be compositions of matter, so two or more substances, something new. You may be able to patent that. Another requirement, and this may seem to be something that's fairly understandable, it has to be novel. So it can't already have been invented or disclosed by somebody else. It has to be non-obvious. So obviousness is one of the main reasons that patent applications get rejected. And something is obvious when you've taken something that exists already and added some little bit to it to try to make it a little bit better. If it's an obvious addition to something that's existing, in that case, you're not going to get to have a patent for it either. Finally, does it confer some useful benefit? This was a bit of a sliding scale, because if you were to look in the patent databases, you would see that there are a lot of wacky things patented out there, but it's amazing just how many squirrel traps there are and squirrel prevention mechanisms. But hey, they're useful, so that's the kind of thing that, technically speaking, is patentable. There's also, you know, within that, trying to think of what is patentable, you then ask yourself, well, what's not patentable? Abstract ideas, the laws of nature, and things that are mere suggestions or ideas, they're not fully realized, cannot be patented. So there needs to be some sort of tipping point where maybe you've designed a machine, haven't built that machine yet, but the design is ready to go. You've got a complete set of something there. But if it's still in its true infancy phase and it's just loosely held together, it's probably not yet ready to be patented. All right, let's move on to trademarks. Trademarks are source identifiers for a particular good or service. To be an identifier, what you're thinking of is some physical representation that tells consumers that these goods or services come from you. Okay, what is the identifier? There's no fixed rule set on what your trademark actually has to look like or be. So you could have a word, one single word. You could have a series of words. You could have a standalone image. You could have a sound. I'm sure you're all aware of the bum, bum, bum. You could have smells. Right now, there's this trend amongst hotels to actually do proprietary scents in the lobbies. So that when you walk in, you're like, oh, I'm in a W, or whichever hotel it happens to be. Product packaging, just the exterior packaging could be something that's a trademark. That's different from product configuration, which is sort of the way something is shaped. You can actually get trademarks for colors. Again, it's for a specific good or service. You can't say, I claim the color blue on everything anywhere. It's very specific attachment to that good or service. And other kind of weird items as well. So some very easy examples of this. You think of the word, or you hear the word Kindle, and you assume that is the e-reader device, and you know that's from Amazon. You see the cherry red lacquer finish on a pair of shoes, and if you wear a lot of high heels, which I hope many of you don't because they're terrible, that might be a Louboutin shoe. And then the bum, bum, bum musical sequence is the NBC chime. So there's three kind of standard examples of one a word, one a color, and one a sound of how you could have a trademark, because all of these things ultimately make consumers think, hey, this item or this service comes from this purveyor. So here are a few examples that you might see out in the world. The Apple logo, the Just Do It slogan from Nike, the Robin's Egg blue box exterior, so there's that product packaging we were talking about from Tiffany's, the cherry red lacquer finish on the underside of the Louboutin, the Coke bottle shape, and no longer in use, I believe, the fuzzy pink mustache from the Lyft ride-sharing service. Okay, let's think a little bit about copyright. Earlier we talked about how it's creative, it's original, and it has to be expressed. So all three of those things must be present in order to have a copyright. Originality means that you actually are the source of it. Didn't borrow it from somebody else. Creative means that there has to be some modicum of expression, some sort of spark that makes it unique and different. And that's a real sliding scale. If you read the case law, which hopefully you don't have to, you'll see that there's no one way of determining what is or is not creative. But importantly, it has to be fixed in a tangible medium. So that means it needs to be rendered somehow. So for example, a literary work, a book, and this could also include software, musical works, dramatic works, choreography, pictorial, graphical, and sculptural works, so paintings, any sculpture you might see, movies and other audio-visual works, sound recordings, architectural works. Any of these could be protected under copyright. Now, like Pat, there are a number of things.
Ashley?
Oh yeah, what's that?
So on the things that can be copyrighted or should be copyrighted, two things come up often when I talk with people about creating their own products. One is fabric design, which is copyrightable.
Yes.
Or is probably copyrighted just from the creation point. So I always recommend that they do their own fabric design so that they're not, accidentally taking something that's copyrighted and putting it into their product.
Yes, yes. And when they're designing their fabric too, that's a moment where they can take into consideration how much creativity here is enough to have it really be mine. Because if you're just doing, let's say, like alternating equal thickness blue and white stripes, you're probably not going to be infringing somebody else's copyright, because that particular pattern has been around forever and no one could hope to claim copyright to it. But something you might see, especially if you're doing, let's say, exterior handbag fabrics, that interlocking LV on the Louis Vuitton bags, the D&B on Dooney and Burke, the fleur-de-lis, number of these patterns can be protected under copyright. So you want to make sure, one, that you're doing something that is, if not wholly original, at least is creative enough to distinguish you, and two, doesn't emulate or copy somebody else's original expression.
The other question I had is that I'm a terrible artist. I cannot draw at all. So I'll hire graphic artists, everything from 99 Designs to Design Crowd to Fiverr or whatever. But once they create my design, I want to copyright it. So what do I do to make sure that I can copyright what they've created, and also that I'm not infringing on their copyright when I use it?
Absolutely. So when you engage a graphic designer or anyone who's creating a copyright work for you, you want to make sure that you have as much of the rights as you can get to that work. There's typically two ways that a copyright can be used by another person. The one way that confers total ownership is an assignment of those rights. Now, when you hired a third party to make something for you, sometimes by virtue of having hired them, that becomes a work for hire. So under the copyright law, it is something that is made for you and then will belong to you. But the copyright law is a little funny in what falls under the category of things which can be considered works for hire. So in addition to make sure that you've got any language in the agreement between you and the designer saying, yes, this is a work for hire and customer owns it, you also want to make sure that there's assignment language in there saying specifically, in as much as any of this cannot be considered a work for hire, I, the artist, also assign to you, the customer, all rights, titles, and interests in this work. And that way, you've got the work fully conveyed over to you, so you can then do with it as you please. The other option is to seek a license of that work. And that license it's a lease, it's a rental of that work. It can be forever, and it can basically allow you to do anything you want with that work. The owner or the creator of the original work just maintains the ownership. So you could say, yeah, I want a license to this work, and I want to be able to use it forever. I want to be able to change it. I want to be able to distribute it. And you can create the list of ways that you need to be able to use that work. As the customer, you're probably going to want to push for an assignment so that you own it outright. As the creator, you might push for a license so that you can pull back those rights later if you want or need to. So when you're reviewing your agreement with them, make sure to be very careful that you're getting the rights that you absolutely need to do what it is you need to do with the work.
Years ago, I used to be a fashion photographer, and we had pre-printed forms that we always filled out because, of course, we were being hired. And even though it's work for hire, you still made sure to sign over all rights to whoever it was that was purchasing it. I'm not sure if those types of forms are still out there, or if in the world of internet, if people are more strict about holding on to their rights and only licensing. But back in the Stone Age, when I did this, it was pretty standard.
Yeah, and we do a lot of, in fact, earlier today I was working on a software development agreement where we actually write in all of the language as to who owns any deliverable at the end. And earlier in the day before that, I was answering a question related to photography and the copyrights in that, in dealing with the idea of who needs to give you releases if physical people are appearing in those works. Because in addition to having the copyright in the original expression, so that photo, if there's a human being in there, you also need to get permission from that human being to use their image anywhere else.
And I have one more question about that as well,
Mhm.
that we get a lot. And that is when you have a logo for your brand. So, for
Mhm.
example, the Apple logo, right?
Yes.
Is it better to copyright it, trademark it, both, or either?
You could do both. With copyright, some of it's going to depend on that creativity threshold. So if the Copyright Office gets something that's very basic in and says, no, sorry, there's not enough original content here, they might reject it. For example, let me think of it. Maybe even just the original Windows logo where it was 4 panels of different colors. That might have lacked creative spark required for copyright registration. But as soon as Microsoft started using it in connection with computers, they were able to trademark it because now they had an image identified with goods that made consumers think of them. So some of it's going to depend on the underlying creativeness of the visual representation to see whether or not you could also get it copyrighted. Disney has tried to extend the life of some of its works by both copywriting and trademarking them. So if you ever want to see a real world example of how it's done, look at some of, or is it Disney or Warner Brothers, one of the two. The Betty Boop case, I believe, is the one that discusses it. So ultimately, it just depends on how creative the underlying work is.
So would you recommend ultimately though that if, so for example, I have a logo,
Mhm.
and it has, paw prints and like little half moons below it. And
Yeah.
then I have my word, right? And I've trademarked the whole thing is as part of it. But I
Mhm.
do have the option, I'm sure, to copyright just the logo
Mhm.
and then, trademark the whole thing and parts of it.
Yeah. I would say go for it then, because especially with copyright registration, the online filing fee for copyright registration is like 35, 45 bucks, something like that. So for that, you might as well. And that way, even if you find somebody using the graphic later, if they're not using it in a trademark sense, you can say like, well, fine, maybe you're not infringing it as a trademark, but you are infringing it as a copyright because you're making copies of it and distributing it without my permission.
Oh, that's a perfect example of why we should do both in
Yep.
that situation. Okay, thank you very much.
Yeah, no
Awesome.
problem. Okay, so yeah, we've talked about some different things that can be copyrighted, but what about things that cannot be copyrighted? Um, Things that aren't actually rendered in that physical medium yet. So improvisational speeches, choreography that hasn't been notated, titles, ingredients, slogans. These fall under short titles and phrases. They're just not original enough to reach that threshold requirement under the Copyright Office. The same is true for common geometric designs. So that square window pane we talked about, you can get a trademark for it possibly, but it might not be original enough to be protected under copyright law. Ideas, again, it needs to be something that's tangibly rendered. And then works that are common property. This one actually covers quite a lot of space. We only put calendars and weight charts down for now, but this can include generally things which are factual. So no one gets to own facts. So if you've got, let's say, mathematical equations, you can't copyright those. If you've got fill in the blank forms that don't really have any other content and it's just a few lines, you might not be able to copyright that. So these items that are really very utilitarian and often factual are things that no one gets to claim ownership of.
So let me ask another question here, which is a lot of our entrepreneurs
Mhm.
almost all have started on Amazon,
Mhm.
and a lot of them are moving into the world of retail as well. But on Amazon, there is a rule of thumb of taking something that is pretty common and making a modification to it. Sometimes that's just the packaging or adding an insert. Is
Mhm.
something that's an insert, instructions, an additional piece of paper with how to use this differently, or perhaps packaging that's unique, or any of those copyrightable?
It would depend on the individual work itself, but something like instructions, where there's no creative spark and it's very utilitarian, probably less likely to be protected under copyright. Because there you're saying things which are basically just, what's the phrase I'm looking for? Above and beyond utilitarian. They're merely informational without providing anything necessarily original or creative.
Okay, so
Yeah.
the instructions that come along with IKEA are purely informative. They're not creative.
Yeah, I mean, IKEA might say that they could, for example, copyright some of the images they've created.
Right.
But generally, you know, somebody saying, insert the lug nut into section A and secure with tool B, then that's probably less likely to be
Or insert 4 AAA batteries is not copyright.
Yeah, like nobody's going to get to claim that.
That makes sense.
Yeah. Yeah, there's just some things that the Copyright Office is like, look, like, just nobody gets it. Nobody does.
I think oftentimes people just assume that because they wrote something, whether or not it's creative, that it's protected because they wrote it. And
yeah, and it's like they think that by virtue of having put work into something, that it means that they have exclusive ownership. But the thing is, it's just not the case where the law is concerned. You know, anything you render, create, probably takes work, but it doesn't mean it's inherently creative to warrant protection under copyright.
got it.
Yeah. All right, next on.
Thank you.
So one thing we get a lot of questions about is, what if you take something that's already pre-existing and tweak it a bit? Can you own that work, or does somebody else own that work? This is a sliding scale, and it's going to be very fact intensive. So if it's something that is very much based and taken from an original work, you probably will need to get the original copyright owner's permission to be able to use or exploit that in any fashion. If it's something where you're only using a very small portion of the work and it's not competitive with the original work, and it's not commercialized, there's a few other factors as well in there, it may be acceptable for you to use that under the fair use doctrine, which basically allows certain instances where you can, as a defense to somebody saying you've infringed their work, say, no, it's okay because, let's say you took a big photograph, like I have one behind me of the mountains, and I was to take a 1-inch corner of that and turn it into a montage which then looked like a human face. My use of that little bit of it may not be considered infringing because it's 1/1000th of the overall new work that's been created. And it's not competing against the original work because somebody buying that face may not be interested in buying a photo of part of Mont Blanc. So it's really a sliding scale of how much you're using, what the new work is, and what the end use is for. Before you borrow, look into it to make certain that you're not inadvertently infringing somebody else's rights.
And that's why we're going to have your contact information at the end of this.
Yes, because it's one of these things where we even have to look at it separately. Like if we see a work that's been adapted, we need to kind of check out, well, what's the feel from the Copyright Office right now? Because it's a temperature that changes pretty regularly and can be nuanced depending on what the work is and how it's used. So just recapping quickly, practical examples of commercial IP. So a patent is a product with unique functionality or a unique non-obvious design. A trademark is a brand, a logo, something that indicates you are the source of certain goods or services. And a copyright, for example, the unique fabric pattern you created, something unique, creative, that is now in a tangible medium. Okay, we get a lot of questions on whether or not I need to register my copyright, my patent, my trademark. And this is all part of the larger asset management, which you as a brand owner or IP holder need to be thinking about. On the patent side, there are 3 main types of patents. provisional, utility, and design. Now, to say there's 3 different types is a little inaccurate, because a provisional is kind of a preparatory application for a utility application. A utility is one that is dealing with some sort of functioning thing. So you can file a provisional, get most of the pieces of your application together, and then convert it into a utility later, which has all other required pieces. A design patent is dealing with something ornamental, so really thinking of an aesthetic. For example, the unique way a bench could be cut might be a design. And you cannot do a provisional for a design patent. I do not do patent prosecution, so we will send any questions on that field elsewhere. Trademark, you can again do the word, you can register packaging, you can register a configuration like the bottle. Copyright, all the registrations are divided out into the different types, so whether it's a literal work, or a sculptural work, etc. When you're thinking about registration too, one of the things that we had touched on earlier was that it's a question of not just whether it's in the US, but how your rights differ when you go abroad. So using trademarks as an example, in the United States, trademark rights are conferred on the first person to use a trademark in commerce. So that means where consumers can get access to it. You could have a state level registration. It only covers you for exclusive rights in your state. You could have a federal registration that gives you nationwide exclusivity. And then you could also seek registration of your trademark in other areas of the world, using either your local counsel to help you set that up, or chatting with counsel in other parts of the world. The rules differ country to country, so if you have rights here, you might not and probably don't have rights somewhere else. So it's very important to think about that international discussion early, so you know how to protect your rights around the world.
And that was one of the questions that we had from that we had from our one of our participants was, just because I trademark something in the US, does that mean I'm protected in other countries? And so you just answered that as no, you do have to look at the other country's requirements and make sure that you protect yourself abroad. And I know in the case of patents, it's very similar. You know, I have a patent in the United States, and that only protects my invention in the United States. So anyone could, but it also protects people from importing my invention and selling it in the United States. But it doesn't protect, though, somebody in China, for example, from creating that same product or that same invention and selling it anywhere in any other country. So I've had to think about what markets do I want to expand into, because it can get very expensive to try and patent or trademark all around the world in all countries. So I've thought about, okay, where do I want my market to be? And then I've discussed that with my attorney as far as, okay, I know I'm primarily aiming for Australia, Canada, whatever, right? And then they work with me on getting my protections in those areas.
Yep, and that's the way to do it, because one big consideration is commercially where you're going to be, and another big consideration is where are you willing to enforce, because having a registration on file will generally at least help third parties know that you exist, and maybe will deter them from seeking registration for something that would otherwise have been infringing. But there's going to be cases where you're going to need to see if you can enforce your rights abroad, and absent that registration, you might have a tough time doing it.
And then real quickly, I know we just talked about it and you're helping me with this right now, but can you talk about the Paris agreements?
Yeah. There's a few different international treaties out there that govern trademark law. For example, you might hear people say international classes, Paris Agreement. That refers to a level of standardization amongst countries that basically when you're trying to decide what you're filing for, you might know what your trademark is, like let's say it's a logo of a plant, but you have to list all of the underlying goods and services you're going to be using in connection with that logo. So the Nice language allows you to have the same or close to the same goods and services around each jurisdiction in which you file, so that you don't have to keep rewriting the rules every time you do another filing. Another thing you might hear about is the Madrid Protocol. And Madrid allows us to basically take an application we've got in your home country and then request registration of that application in lots of other countries. And if you're doing a big batch filing, that can oftentimes be less expensive than going individually to each country and asking local counsel to do it there. The downside to Madrid is that if anything happens to your US application, you have to go through a process called transformation, because then you have to basically refile any foreign application upon which your US application, or upon which the US application was sort of the starter application, and do it all over. So you want to make sure that if you ever use Madrid, that you have a very strong home application so that it's not going to endanger your foreign filings.
Yeah, I've talked to a lot of people who are convinced that if they watch a couple of YouTube videos, they have all the skills necessary to file for a trademark. And my advice has always been pretty simple. No, talk to an attorney.
Yeah, I've even seen other law firms screw it up, and I'm just like, oh gosh, guys, I mean, it can be a short conversation too, just to get the help, even just to steer you back in the right direction. But it's one thing that once you get something filed, it can start this whole snowball effect of things that are wrong with the filing and the subsequent filing. So you want to try to get it right from the start, because it's not only a cost scenario, it's a question of like, how much time did you just lose in having set your application back a year or two?
Yeah. So one other thing, and I may be jumping into your presentation in the wrong spot here, but can you take a moment and talk about classes? Because a lot of people are a little bit confused about what a class is when it comes to trademark.
Yep. So class is basically an equivalent to the phrase category, or the word category. Every conceivable service or good in the world has been divided up into international classes, and they're paired numerically. So, for example, most wearable apparel items are in international class 25. Items of apparel which are for safety are in a different class or category. And software, typically, if it's a downloadable software or a locally installed software, that's in class 9. If it's software as a service, it's in class 42. If it's what I call nonfiction, and that it deals with something scientific or not entertainment, and class 41 if it's educational or entertainment related. So the reason that figuring out what classes you are in is important is because, by and large, trademark offices charge according to how many classes you're seeking registration in. And it also helps the examiners, not just in your home country, but in other parts of the world, figure out whether or not your mark could be conflicting with another mark. So when your application is filed, the examining attorney will look at the mark itself, the classes that you're seeking registration in, and those specific goods and services, and run a search, including those parameters, to try to figure out if there's already somebody else who's ahead of you, and that person who's ahead of you might be blocking your application. So it's important to make sure you're accurately identifying your goods and services, not only just what they are in terms of the words, like t-shirts, baseball caps, etc., but that they're in the right class, so that your mark is where it's supposed to be, so that when somebody else files months, years from now, they can find you as easily as you can find them.
Right.
And what about if you have multiple classes later that you want to add on to your existing filing as your brand grows? So let's say I'm in pets now, but I end up in the home goods category, and I really need to add on classes. Is that easy to do?
I'm going to go with yes. There's the way that trademark attorneys think of trademarks, and then there's the way that everybody else thinks of trademarks. And you sort of look at a trademark like, let's say like the Nike swoosh, and you think, okay, it's used on t-shirts, sneakers, athletic equipment, all this. If we were to actually go to the trademark database right now and pull up all the swoosh trademarks, there's probably dozens of them, because each time that Nike adds a new good or service, they actually have to file a new trademark application. And kind of the rule of thumb with trademark applications is once you've prepared your goods and services list, you can delete things from that, but you can't add things later on. And the logic behind that is that when the trademark examiner does that initial search, and it's right after you file your application, it's one of the first things they do. They're looking in those specific classes for those specific goods. So if you were to come back later and be able to say, oh, I'm also adding, disposable diapers and kitchen sinks, then the trademark application review process would have to start all over from the beginning. They're cool with you deleting stuff because they've already checked that stuff. So if you're deleting something, it's fine. They don't need to do any other work aside from actually delete those line item goods from your application. But anytime you're going to be expanding your brand, you actually will need to start the trademark application process over again.
Okay, so you basically have to file for a new trademark, but you're already the owner of that particular word or mark, so that's fine. You're just filing a new class for that existing trademark or word.
Yeah, and in fact, you can even add new things in the same class as well. Like in that apparel class, sometimes we've had people who started with, let's say they started with just like wearables. So they've got jackets and blazers, and then they decided to go into like sunglasses. Actually, that would be in class 9. But as they add on accessory items, they're like, oh, okay, now I've got to protect all of these things too. So they go ahead and add those. The one tweak is that you can take an existing item in an identification of goods and services, and you can make it more clear what that item is. So let's say you were doing like building materials and you had scaffolding. You could say scaffolding, namely scaffolding for the exterior construction of commercial buildings. So you're not actually adding another good, you're just better explaining the one you've already got in there.
Got it. So so the main rule is that, for example, I have my class is pet things. But if I were to go back and add in, like, if I started designing watches with animals on them, then I would still have to file a new trademark with that class. I couldn't go back to my original application and say, now I'm adding this class. I can add the class. I just have to file a new application.
Correct.
Got it.
And then before we leave this discussion, and I know this because you and I have done this together, Ashley. I know what my business plan is, so I know where I want to expand. And we originally filed for a number of classes, but I do not get to use the little circle R until I actually have proof of commerce in every one of the classes on that particular filing. Am I correct?
Close. You don't get to use the circle R until you've actually got the registration of certificate. And you can't get the registration certificate until you're using all of those goods in interstate commerce.
Perfect. Thank you.
So, yeah, there's a little window in which you would do the filing to tell the trademark office you're now providing all those goods in interstate commerce, and then they'll review that filing, and once they've green-lighted it, they'll send your certificate of registration, and then you can run amok with that circle R.
And it's my understanding that I have 6 months to do all of them, to have interstate commerce in every one of my classes. And if I don't, I can then get an extension. And then I have another 6 months and so on. But I don't get that circle R registration opportunity until I have all of them actually being sold.
Exactly. And we even have clients who, let's say they start off with a big list of things. They get, a year into it and they're like, gosh, we're already using the trademark on everything we listed in class 9, but 41 and 42 still look like a long ways out. I don't want to keep having to do extensions for the next 2 years when I could get a registration on those other things. We can actually divide the application into more than one application so that if you've got things that are already being used in commerce that you could get a registration for, you partition those out and then you take the remaining items and put those in a different application and let those just sit on the back burner.
And this becomes important to people who are selling on Amazon, because that registration opens up a broad range of opportunities they would not have if they were not brand registered.
Absolutely. And you know what? Getting the registration really makes it so much easier to enforce your mark too, because the other thing is, if you see somebody ripping off your brand on Facebook, on Instagram, LinkedIn, Twitter, what have you, they'll act much faster to take down the infringing content if you can point them to a registration. So all part of better brand awareness and maintenance.
Thanks.
Yeah. All right, so speaking of why should I register, presumption of validity. Somebody has to try to prove that you are not the owner of the mark. Exclusivity gives you exclusive rights to that use of that mark in whatever jurisdiction you registered it in. Ease of online enforcement. I mean, you could have Facebook take something down in a matter of hours if you have a registration in place. You can use it as a registration with customs to be able to enforce your rights and monitor infringing or gray market goods. Injunctive relief at the courts. This is important because it's hard to establish when you're only basing your rights off of unregistered use that you need to stop somebody else from using your copyright or your trademark. Having the registration makes it a lot easier to get injunctive relief. And in the event you actually have to litigate something for the long run, it's a better damages award in litigation. So you might actually get more monetary damages if you have a registration.
And my favorite, this one comes from experience back when I was doing photography, is that if you have your copyright registered and you win as the plaintiff, the defendant has to pay your attorney fees.
Yeah, I think like part of the damages calculation in copyright is that there's a variety of flavors of damages that you can choose from in copyright, and depending on how it's infringed, you may be able to get your attorney's fees. And that's also true in trademark. It's not a guarantee, but there's situations in which you can get attorney's fees for trademark infringement.
Yeah, that was fun. I mean, that was good.
Litigation. All right, so thinking a little bit about protecting your IP, we touched on some of this already. The idea is that really maintaining your portfolio will allow you to protect and grow your rights and enforce them throughout the world. So whether it's patents and you're thinking of doing licensing or litigation, trademarks, if you've got a registered mark, it can be a lot easier than if you're operating on your unregistered or common law rights. Copyrights, registration means that you get injunctions and enforcement a lot more easily. And then we already talked about this earlier, US rights versus international rights. Just checking with counsel to see how your rights might be interpreted in other parts of the world. We touched a bit on this too. Does the IP created by your business belong to you? This is important because even within the different intellectual property fields, the default ownerships can be different. So you want to make sure that whether it's an employee or an independent contractor, that you have got language in there stating that you either own anything they create outright, which if they're employees, it defaults to them, or that they're going to license everything they need to you so that you can use it in whatever way you need to. There's going to be things that are created by people who work from you that might not be considered intellectual property. That doesn't mean that those things aren't confidential or proprietary in some way. It just means they don't fall into the intellectual property camps. So you also want to make sure that in any agreement with a contractor or employee that you've got trade secret protection in there, so confidential proprietary information is protected, and that they know that they're not allowed to use or disseminate that without your permission. So make sure to carefully read those confidentiality provisions so that you are protected in the event that something that's created doesn't fall into one of those IP camps.
I'll real quickly touch on that for a moment to remind everyone who is watching this, when we talked to Isaac, the sourcing agent, He talked about making sure that your sourcing agent signs an NNN, because your sourcing agent may not be involved in specific trademark or copyright, but they are involved in proprietary business information. So you want to make sure that's protected.
Absolutely, yeah. Making sure that your distributors, publishers, or other third parties are protecting your IP and only using it in as much as they are authorized to do so. One thing we see a little bit more lately, especially with just the ongoing use in social media, is how do you treat people who are fans of your IP? People who are creating maybe, homage videos, doing other, like when we see the ride sharing services, we see people decking out their Uber and their Lyft vehicles, and becoming sort of personas even within those companies. So you want to think carefully about when you're enforcing your rights. Is enforcement an opportunity in that is that third party someone who maybe you don't need to be thinking about this as I have to get them to stop thing, but maybe there's an opportunity there to say, hey, like you're actually promoting our brand in a way, let's legitimize this so that we're both winning. So, look at it from both a rights and enforcement standpoint and from just a very practical business standpoint. Okay, and we've come to the end of our prepared materials. So that hopefully is a nice overview to give you a little bit of background on the different areas of intellectual property and considerations for your business. Any questions?
So I'm going to go back through and just make sure that we answered all the questions from the beginning that our folks had. So one of the questions was, do I trademark one word or two separate words? And I think we answered that. You would trademark both words as part of your trademark, right?
Mm-hmm. Or if you, it depends ultimately on how they're going to be displayed. So if you've got a couple words, if they're always going to be together, trademark them as one application. But if you're going to have times where they appear on two different parts of a page and then times where they're adjacent to each other, maybe those are two separate trademarks that can also just appear nearby one another. And so you do separate filings for those.
Yeah, I learned this lesson with my trademark because I trademarked initially the word itself, SIFTEs, and then I trademarked as part of it the tagline.
Mm-hmm.
And so now I'm having to file a separate trademark application specifically just to use it without the tagline.
Yep.
So I've kind of learned my lesson there, but at least now I have the full thing trademarked. But now I need to file both. So you do have multiple options, and I think that's what this discussion has brought up. And then the second thing was, do I need to have separate protection in many countries, which we did cover that.
Cool.
And then if it is just the name that is trademarked, can you have, is it just the name that's trademarked, or does it actually protect the product as part of that trademark if that product is associated with that trademark?
Mm-hmm. And that'll depend on how the trademark is incorporated into the product. Like if the trademark is incorporated into the packaging in some way or into the configuration in some way, like you think about the Coke bottle, the Coca-Cola logo is actually on the glass. So in that way, it's sort of a dual protection. And when we see packaging, we see special packaging configurations that consist of certain elements that actually in whole become separately protectable. So you might have your word trademark on there, but then you have a very specific color aesthetic on there, or even a photographic image on there that people are going to react to and say, this is sourced from this company. So now I know who it's for. So it ultimately depends on how your buying public is going to react to something.
Yeah, and I noticed when you do your application, you have to send in photos of your product with that logo on it, with that trademark on it, so that they can view it being used in commerce. So I had to do many forms of that.
And you know what? We call those specimens in trademark parlance, and they're a tough thing to get right sometimes. And it's one of the ways in that attorneys get hired halfway through the process, is because the specimen that was submitted wasn't abiding by the terms of the trademark manual. And I've been doing specimens for years, and even now I still get somewhere I'll get a specimen refused. I'm like, you gotta be kidding me, because I thought it was a spot on specimen. But the trademark office is very particular about what will qualify as evidence of use, and it differs depending on whether you are providing a specimen for goods or a specimen for services.
Got it. And then the last question that we had was just talking about, and of course we know that you're not a patent attorney. However, we talked just a little bit about when is the right time to file for a patent. So if I'm coming up with a creative idea and like, oh, I think I have this good idea, and I've got it prototyped, and I think I know how it functions. Is that the right time to put it into a patent, or is there some consideration there?
Yeah, and it kind of depends on whether it's still an abstract idea or whether it's a fully fledged thing. And a patent attorney can definitely help you make the call on what that could be. And if you're in doubt and you want to kind of talk to people about it, if you're talking to an attorney, even before you hire an attorney, just by virtue of disclosing something like that, it's protected under privilege. So you don't have to worry about your attorney then going and filing for your patent themselves. But this is a good spot too to think about using NDAs, confidentiality agreements, to make sure that as you talk to people, you're really trying to make sure you don't inadvertently give away something confidential. So consider using confidentiality agreements where necessary to make sure that you're not inadvertently giving away your rights.
Yeah, and I think the other thing that people are often afraid of is, this. I went to some training by Damon John, the shark from Shark Tank, and his team was saying, "Oh, you don't want to patent anything. That's like $100,000," and it's just. And so I think it just invokes fear in people where they're afraid to even contact an attorney. But in every single case, I mean, here you are talking to us out of the goodness of your heart today, right? But in every single case that I've ever reached out to an attorney, they don't charge you for giving you, just advice initially of what you should do. My attorney only charges me when he does work and files things for me. So it's great to be able to reach out to him and say, hey, I've got this going on. What do you recommend? And then he'll tell me, hey, okay, I recommend this. Here are your options. Do you want me to go ahead and do that work? And then he gives me that quote to do that work. So there's nothing wrong with calling an attorney and saying, hey, I'm thinking about patenting this idea. Am I at the right spot? And getting their initial counsel. It's not like they're going to charge you $4,000 to do that. It's just they start work for you. So don't be afraid to call an attorney and ask a question, right?
Yeah. Well, the other thing is, don't be afraid to ask if we're charging, because there are, when you come at it from the attorney perspective, there's a lot of, especially with people who might be new clients, we're just trying to build a roadmap, and we want to figure out if we can help you, if we need to send you to somebody else who might be, if when Stephen came to me, it was like, oh, hey, design patent. I was like, la, 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 no. So I sent him off to Sam. But part of it is we're trying to get you to the right place, and maybe that right place isn't us, but maybe you come back to us when we are the right place. And the other thing is, if you're an existing client and you have a question, just drop your attorney a line and say, hey, I'd like to talk about this. Is this something billable? So that you could know whether it is on the clock or not, and just ask. I mean, we don't mind, because sometimes it's things that aren't billable. Sometimes it's things where we're like, well, we're going to be providing advice. We're going to have to do this back end work to get to your answer. So yes, that is. And, we don't mind you asking. That way everybody knows and nobody gets mad at bills or wonders where the bill is later.
So I've got a couple of other questions, and just a quick shout out. You mentioned Sam. We're as I mentioned earlier, we're trying to get Sam to do a specific patent presentation as well. He's great. I love him. So a couple of questions. One, I want to revisit the question about the two words. I'm going to give you the example is my shop, two words. That's the name of the hypothetical name of the company.
Mm-hmm.
The URL is www.myshop, one word, .com. So our entrepreneur is concerned that she has to trademark my shop as one word, as well as my shop, those two words, in order to be protected.
Yeah, and probably not. What she wants to protect is the way that she's going to be displaying it the most often. So if it's my hyphen shop, that's what she should register. Trademark infringement is based on looking at a lot of factors, and one of the main factors is the physical resemblance between one mark and the next. And that physical resemblance is not just a visual resemblance, but it's sight in the visual, sound in how it's spoken, and meaning. So as far as the visual is concerned, if the elements are my hyphen shop, if you don't have the hyphen, it's still 2 out of 3. It's going to sound exactly the same because people aren't going to say my hyphen shop. They're going to say my shop, and it's going to mean the same thing. So from that perspective, really just if you can't get the hyphen in the domain name because somebody else already took that domain name, don't worry about needing to register every possible trademark iteration of it. Register the one that you use, and then small differences between marks aren't going to be enough to obviate confusion if somebody else comes along and it tries to adopt. And that's why when people are like, oh, I saw that somebody else had this trademark and yeah, they're using it for the same thing as me, but I'm just going to add an exclamation point to it. It should be fine. I'm like, no, that's not fine.
Okay, got a couple of other questions. One is there's a lot of confusion between a design mark and a word mark. And I'm not sure if I'm using the right words there. And when someone has both a design mark or a logo and a word mark, the name of their product, which one should they trademark? Should they trademark both? And if they do only one, which should they do first?
Mm-hmm. I would say generally we want to do the word mark first, because when you file for a word mark, you're filing for it in what we call standard characters. So the trademark office is going to assume that you're going to use that with whatever aesthetic you want. So let's say your trademark is the end. If you just file in standard characters, it could be the end in purple. It could be the end in big, 80s homage bubble letters. It could be the end in drippy blood letters. It could be any of those things, and you have protected all of it. When we want to register either stylized, which just means lightly designed word marks, or design marks, which really have a strong aesthetic, what we want to think of is this fixed in that we feel pretty sure this is going to be the aesthetic we're going with. We're not making a lot of changes, this is it. Because I feel like a lot of startups, once they start looking at logos and aesthetics, it's not really quite gelled yet. So it's better to give it a little bit of time and get the one you really want. Then the other thought is, if the underlying literal components were changed, is this aesthetic strong enough to where people would still think it's the same thing? So to give you a kind of a visual exercise, think of the Snickers candy bar wrapper. If you were to change that word to anything else, let's say Jardin or something, if it's still in that same color pattern, that same font, and that same layout, you're going to assume it's somehow related to Mars Company because they've just maybe they've expanded the Snickers brand, and who are you to know? But it's the same color and the same font and it's on the same candy bars, so probably they're somehow related. So if you were to drop the bottom out of any literal element, if that aesthetic is still that strong, that's where you're yeah, we want to lock in the visual features that accompany this.
So that leads us to a couple of other questions.
Cool.
So, I've got Acme Widgets, and I've got Acme Widgets is the name of my company, so my brand. I want to trademark that. But I've also got this wonderful little circle with 15 little arms coming out of it, and they're all pointing down except for one is pointing up, and it's unique, and we're before seen. That's my logo, and I want that just recognized when it's by itself, because one day I'm going to be as famous as Nike. Which of those do I trademark? How do I trademark my little strange circle with 15 hands? And which do I do first?
You could do them at the same time if you wanted to. If you really love them both, you can do the word mark in one filing and the widget in another. And if they're, the widget guy is going to be in a different spot on your packaging than the words, or maybe it's always going to be next to it in a certain way. It's whatever way the aesthetic is going to be consistent. That's kind of where you want to work back from in terms of the application preparation part of it. And your attorney can help you talk through this as well. As far as kind of the guts of it, we also talk about the mechanics of actually registering something that's aesthetic, because the trademark office, unlike a word mark where you're just saying, oh, my words are AT&T, with a logo mark, you're having to physically, as part of the application, describe it. So like I'm looking at a little planter next to me right now, and it's got an olive branch, and then to the right of the olive branch is the word olive in brown silhouetted against green. So we'd actually have to describe it with that level of particularity. But the thing is, almost no one gets it right on the first try. The examiner is going to tweak it and then send it back and say if it's okay. So don't lose sleep over how to describe it, what the different aesthetic elements are. The examiner will work with you.
Good. 2 more questions, and I think that's it, so bear with me.
All right.
One is, okay, so now you've got your trademark filed, and you've reached a point where you can legally use the little TM, or you go all the way through and it's registered, and you've got that little R in the circle, you're excited. Can you now write Acme Widgets ever again without putting that little symbol there, or do you have to put that little symbol there for the rest of your life? And it's life.
As far as your customer-facing materials go, you'll want to throw it out in the main spot it's going to be. So let's say you've got instructions that accompany your packaging. The first spot that people see the Acme widget, put a circle R up there. You probably don't need it for the rest of the instructional materials. In fact, for anyone watching, if you go to the website inta.org, they've got informational materials for the public about how best to mark your trademark materials after you've gotten to that point. So there's a business guide that they have that says, hey, if you're displaying it here, use it here and here. One thing you need to consider too is marking requirements differ country to country. So maybe it's okay to put the circle R in it if it's in the US, but if you don't have it registered in Mexico, maybe you're not supposed to do that.
So let's follow up on that for a second. Just as a word out there, and I'm not an attorney, so the attorney can jump on this afterwards and say that's correct. Do not put a little circle R next to your trademark if you are not yet registered. That's just not.
That is very correct.
That's actually like breaking all the rules.
Yeah, in fact, I've had people send me specimens for their applications, and they send it in with the circle R on it. I'm like, you gotta do it over. Sorry.
And it's not that they're doing. Oftentimes, it's the graphic artist who's new and says, "Oh, I know I'm supposed to use this, so I stick it on or something."
Yeah, they don't know any better. So, yep.
And then the last thing I wanted to talk about, going back to copyright and so on, but there's lots of stock image sources out there these days. I use Dreamstime all the time because I love it, but there's lots of the other stock files. And whenever I use it, I always, I'm extra cautious. I always follow up with an email making sure that this is how I'm going to use it and do I have the rights to use it. But the idea of images that come from stock, how do you make sure you can use them? How do you use them? And even worse or better, people who just take pictures from the internet and say, well, it's been out there for so long that it must be able to be used by anyone. Can you touch on that for a moment?
Oh, yeah. So as somebody who's had to respond to numerous cease and desist letters from sources like Getty, who are like, you're infringing, read the terms of service or terms of use that come with your stock image to make sure that one, you have the rights to do whatever it is you intend to do with the image, and two, that whoever's providing the image for you will get your back in the event that the owner comes along and is like, where did you get this? So you want to have indemnification from the other guy saying like, oh yeah, no, I'll protect you if you get chased after by a third party. So really make sure those two things are there. Where if it's going to be an image that's very important to your company, try to buy it outright. If you can avoid a perpetual license or a license with a lot of restrictions, do so, because I had one client years ago who just licensed the image and they got a limited license, so it didn't really give them everything they needed forever. It gave them a little bit of what they needed then. And then they got really popular, and then years later, the owner of the copyright was like, well, now you're big, you can afford to spend a lot more on this. So they feel like they got a bit extorted in that process because they bought what they could afford, and then they ended up paying a lot more for it later. As far as, oh, it's just on the internet and it's probably cool. I had a client who had their website built by a third party, and the website designer put up all these images, and then sure enough, it's the client who gets the cease and desist letter from somebody who's like, why is my photo from my blog showing up on your website? And the client had no idea why, because the graphic designer had put it up. But it's one of those things where you need explicit permission, either by virtue of a license or by virtue of an assignment, to use something, unless it's so old, and you'd have to be pretty confident about the data on this, that it's so old that it's actually public domain now. So the rule of thumb, if it's not at least 100 years old, do not assume that it's in public domain. Good,
I'm in public domain.
Oh, please.
Yeah, I have never had a web designer create a website for me that did not steal images from online someplace.
Oh God, even my own website. I've been building a website the last few weeks myself, and my cohort on this, he's like, oh, hey, what do you think of this picture? I'm like, where did you get that picture? Do you have the rights to that photo?
Yeah, that's what I say. I love Dreams Time because I just pay a monthly subscription, and I know I can just go out there at any time and pull down what I need.
I'm gonna have to check that one out.